Welcome, everyone. And thank you for being here today. We're glad you carved out some time this afternoon for a conversation about estate planning essentials. My name is Emily Tierney Petty, and I'm part of the wealth management team here at Windward. For those of you who are new to us, Windward's a fee-only fiduciary wealth management firm based in Kansas City. We've been helping families build, preserve, and transfer wealth since 1999. Our roots are in a CPA firm, which means tax strategy is not something that we just bolt on to the end of our plans. It's woven into everything that we do. Today, we're going to spend 45 minutes talking about estate planning. Estate planning is one of those topics that people know that they should address, but it tends to get deferred. There's always something more pressing, or the deadline feels far away, the process feels complicated and not fun to think about. We hear this from families all the time. Then something happens, whether it's a health scare, a family change, or a conversation with a friend or family member who just went through a difficult situation. And suddenly, it does feel urgent. Our goal today is to give you the clarity to act thoughtfully, not reactively. Before we get into the content, let me introduce the team you're going to be hearing from today. So you're going to be hearing from three of us. Drew Osborne is a senior wealth manager and CEO here at Windward. Many of you know Drew, and he'll be leading several of our sections on the financial and tax dimensions of estate planning. I'm Emily Tierney Petty. I'm also a senior wealth manager at Windward, and I'll be guiding us through the opening and closing. Drew and I are delighted to have Stephanie Kleyh joining us today. Stephanie is counsel at Kirkland Hochstetler, and she brings a practicing estate planning attorney's perspective to today's conversation. I do want to be transparent. Stephanie's not a client of Windward, and she's not affiliated with our firm in any capacity, and she's not received any compensation for being here today. She's participating entirely in her own professional capacity, and we're very grateful for her time and expertise. Windward's team includes financial advisors and CPAs, not attorneys. This webinar is meant to be educational in nature. Nothing that we cover here today constitutes as legal advice, and we will not be discussing the drafting of specific legal documents. What we will do is help you understand the financial and tax dimensions of estate planning, explain how we coordinate with our clients' estate planning attorneys, and give you a clear picture of when and how to take action. With that, let us look at what we have planned on the agenda for today. So we have 5 sections that we're going to move through at a pretty steady pace. Feel free to drop any questions you have into the chat box at any time. We're going to save a little bit of time at the end for questions. And if we don't get to your specific question, please note that we will follow up with you directly after the webinar. So first, we're going to start with what estate planning actually involves, because the term gets used loosely and there are some important misconceptions worth addressing up front about who it's for and what it really does. From there, we're going to move into the 2026 estate tax landscape. There's been some pretty significant legislative change in the past year that's reshaped how families should be thinking about wealth transfer. And we just want to make sure that everyone understands what changed and what that means. The third section is where we're going to get into the financial and tax dimensions of estate planning, the specific areas that we review with every client as part of our integrated planning process. And this is where CPA's heritage adds a lot of value. Fourth, we're going to spend dedicated time on beneficiary designations, which in our experience is the single most overlooked element of a well-coordinated estate plan. The stakes are high and the fix is simple, but only if you know how to look. Then we're going to close with some practical guidance on when to reconnect with your estate planning attorney and what questions to bring to that conversation. So, with that, let's dive in.
Yes. What estate planning really involves. So, where I want to start is what I think is one of the most common misconceptions that we hear is that estate planning is only for the wealthy. We hear that a lot. And I think it's one of the most consequential misunderstandings, not just in estate planning, but just finance in general, because it causes people to delay planning that ultimately protects themselves and their families. If you own a home, if you have kids, grandkids, if you have a retirement account, or if you just have people in your life that you care about, you need an estate plan. And the complexities of that plan are going to depend on your situation, but the need for one is nearly universal. So, what estate planning really is at its core is a set of decisions about what happens to your assets and your health care if something happens to you. Who's going to receive your wealth? Who makes decisions on your behalf if you cannot? Who takes care of your kids? How does your wealth pass to the next generation in the most tax efficient way possible? So these aren't questions only for wealthy people to answer. They're questions that really everybody and every family needs to answer. And the cost of not answering them often ends up on the people that you love the most. That right side of the slide says what estate planning isn't, or rather what it's not limited to. It's not about just writing a will, though obviously that's essential and a foundational part of any estate plan. It's not primarily about avoiding estate tax because for most families now, it's not really a concern. And most importantly, it's not something that you just do one time, put in a drawer, and never revisit because we've seen clients who come in with estate documents 15 or 20 years old, naming beneficiaries who've passed away, reflecting life circumstances that have completely changed. An estate plan is a living strategy and it needs to be treated that way. So, with that, we'll kind of go on to our next slide, which are the core documents that every family needs. So, this is where, Stephanie, we want you to come in and talk to us about these core documents.
Absolutely. So thanks for having me, guys. I'm glad to be here. And as you can see on your screen, these generally are some categories of documents that everyone may or may not need. We can start up there with a will. So people commonly hear it's pretty known, oh, you need to have a will. When I meet with clients, I try to make it pretty clear that you do probably need a will. It's a good document to have, but a will is simply a backup plan to other estate planning tools that we have. A will doesn't avoid probate. That's a fairly common misconception. A will is actually a set of instructions that you give to the probate court if an asset of yours ends up in probate. So again, probate, kind of a four-letter word around my office. It takes forever. It's very expensive. So ideally, we're not ending up there. And avoiding probate is actually as easy as making sure you have proper beneficiary designations on all of your assets. So kind of sliding over beneficiary designations, and we'll get into that in more detail here in a little bit, but that's that's the way to make sure that your assets pass efficiently to your intended beneficiaries. Now, that might include your house, it might include your retirement funds, your bank accounts, your cars, business interests, basically anything you own needs a beneficiary designation. That's how you avoid probate. Um, Now, the will again catches anything you don't properly title. And a trust is kind of an ancillary document that not everyone might need. It kind of depends on your situation and your distribution goals as to whether or not I would recommend a trust for you. Um, Trusts are very common in spreading out distributions to minor beneficiaries or beneficiaries who may not responsibly handle money yet, and you just kind of want some oversight. A trust can be a useful tool to make sure that the assets you've worked hard for are managed properly until your beneficiaries reach the age and stage where they can handle that on their own. The other aspect of an estate plan is not so much dealing with your stuff after you're gone, but dealing more with appointing proper people to help you take care of yourself during your lifetime. So that's power of attorney documents. I always recommend one for healthcare and one for financial needs. And essentially, that's you appointing the people you choose to help you make medical decisions or to pay bills in the event you're incapacitated. So honestly, oftentimes, I mean, you're still living when powers of attorney are in place. They might be more important than where's my stuff going to go when I'm no longer here. But these comprehensive 5 categories, they're great. Every good estate plan should at least touch on these or discuss the necessity of each one.
Thanks, Stephanie. That's really helpful. And when we were talking ahead of this, and we kind of looked at this, and we're like, here's kind of 5 categories of documents, and beneficiary designations is not necessarily just a document, but you're like, well, it's a key document. If you have real estate, if you have a house, is a beneficiary deed. So that for sure fits in here as if you have
Yeah,
it,
so
you should.
a lot of people's one of their main assets, biggest thing you ever
Yeah,
purchased, you always hear that is your house. So transferring a house efficiently outside of probate is done with a beneficiary deed document. If you own a house, you need a beneficiary deed. So
yeah,
whether you have a trust, no trust, crazy kids, whatever it is, get a beneficiary deed.
yeah. Okay, so then the next slide we'll talk a little bit about estate tax. It gets kind of brought up a lot. People are curious about, am I going to pay estate tax? How does that work? And we'll talk about kind of the legislative context here because really the last year has brought significant changes to how things work. For years, there were estate planning conversations kind of shaped around this ticking clock. So back in 2017, the Tax Cuts and Jobs Act of 2017, it made the federal estate tax exemption much bigger than it was prior to that. It basically doubled it. But it built in this sunset provision that would have cut the exemption basically in half at the end of 2025. So a lot of conversations that we had with clients, last year and in 2024, for families with larger estates, it created this sense of, is there something we need to do? That we need to use part of our provisions, make some bigger gifts, before this exemption dropped? But that uncertainty was resolved with the One Big Beautiful Bill Act, which was signed into law July 4th, 2025. So, Stephanie, can you talk some more about that, the impact on the estate tax from that?
Sure, absolutely. So, yes, the One Big Beautiful Bill, among other things, really made estate planning a lot easier on most people because it increased your lifetime estate tax exemption up to $15 million per person. And now for married couples, that's transferable. So a married couple has an exemption of $30 million, which basically that means you can pass on up to 15 or $30 million worth of assets to your beneficiaries before any estate taxes come into play. So whereas several years ago, we might have been concerned in the estate plan about getting around some of these tax issues, now it's just simplified because most people don't necessarily need to worry about avoiding estate taxes. You just fall under the limits and you're there.
Right. And where the previous, act that, was specific to a state law, it had this sunset provision that was going to end in 2025. The One Big Beautiful Bill basically made this permanent. And so the fact that it's permanent until Congress changes it, which who knows, with the trajectory of federal debt, political landscape, there's no guarantee that these exemptions are going to last indefinitely, but we know that we have kind of this window right now of clarity. There's not urgency to, do anything drastic. It changes the planning conversation itself. So with estate tax, essentially off the table for most families, the focus shifts to tax efficiency, basis planning, the structure of how assets, pass. Those are the conversations that Windward were positioned well to kind of lead those things. The next slide is going to talk about at a state level. So, Stephanie, you and Windward too, we primarily work with people in Kansas and Missouri. Can you talk about the state, estate, and inheritance tax considerations?
Absolutely. Yeah. So more good news here. Kansas and Missouri, along with most other states, do not currently have an inheritance tax. So that's a very common question I get from my clients. They come in and they're worried about passing all of their assets on to their kids because they expect the kids will have to pay some sort of tax for inheriting that, which again, that's kind of another common misconception, especially around here, as Missouri and Kansas do not impose any estate inheritance taxes. So essentially, when we're dealing with taxes, it's more on an income tax situation. There is no inheritance tax. So your beneficiaries can inherit and potentially not pay a single dime in taxes if things are transferred properly.
Yep. And most states don't have any kind of an estate or inheritance tax, but obviously there are some that do. And um, we work with clients primarily in this, the greater Kansas City area, but we have clients all over. And so each situation is unique, and we love to consider that based on what's going on. But for most of our folks, the planning conversations that we can focus on are going to be specific to how do we be tax efficient? What strategies do we want to employ to make sure that kind of wealth can stay within a family over the long term without having to kind of navigate and worry about what's going to happen for most folks, a federal estate level or state, which is pretty good. So next slide is going to just at a high level talk about how Windward coordinates alongside estate attorneys from a financial and tax perspective and the dimensions. So, this gets to the heart of what we feel like we do in the context of estate planning and why the integration of financial planning, tax strategy, and estate planning, it matters so much. So obviously, like Emily said, we at Windward, we are not attorneys. But the financial and tax dimension is real for every estate plan. So 6 of those areas that we review with our Windward clients are below. So basis planning. In most cases, when an asset is held until death, the heir is going to receive a step up in basis to the fair market value at the date of death, which means that unrealized capital gain accumulation during an owner's lifetime, it disappears from a tax standpoint. And when families have highly appreciated assets, whether that's real estate or investment accounts or business interests, that step up can be worth a significant amount of money. And with the higher estate exemption, a lot of families that the focus kind of shifts now rather than potentially gifting some assets during one's life, it's often better to hold them until death and giving an heir the stepped up basis, which could be obviously a more tax efficient strategy. So that's something we model with our clients to consider. Does it make sense to gift any or to hold it over the course of your life? Formula clause review. So a lot of older trust documents written before the 2017 and 2025 law changes, they contained sometimes these formula clauses designed to fund these credit shelter or bypass trusts to maximize the amount of money that could pass free if they were going to pay a state tax. So lots of big words in what I just said. But the point is that this old strategy to lower a person's estate tax may not apply anymore. And that old strategy might increase the tax burden if those clauses are still in place if they haven't been updated. So it's one of the things that we think is really important that sometimes we see it and we flag it for our clients. Again, not attorneys, but hey, this is here. That's a conversation for your estate planning attorney, but often we can be there to help identify it. So that next idea of beneficiary alignment, we at Windward, we are regularly getting to review account beneficiary designations to make sure that they are current, intentional, and consistent with the overall estate plan. And it's something we do proactively with our clients as part of our regular planning conversations. It's not just if you're a client and you think of it and you ask us, that we'll look at it like, no, it's that important. It's part of what we do. That next point about Roth and IRA coordination. So a different legislative piece, the Secure Act, it changed significantly how retirement accounts pass to heirs. So for most non-spouses, there's a 10-year distribution rule for beneficiaries, and it creates real tax planning complexity and opportunity because heirs may be forced to take big distributions. And if, um, parents or grandparents pass, a lot of times that means people might be inheriting money in maybe their high income years. So we like to think through how retirement accounts fit into this broader transfer picture, including whether Roth conversions during an owner's lifetime could help reduce the tax burden, A, for our clients and potentially for their heirs too. So the next point, gifting strategy. So there's multiple ways people can strategically gift assets to children, grandchildren, or anyone else. In 2026, any individual can gift up to 19,000 per recipient or 38,000 as a married couple without the need to report that gift as part of your lifetime estate. Direct payments to help pay for tuition or direct payments to pay for qualifying medical expenses are two other strategies that if a person wants to make significant gifts, there's opportunities out there. The direct tuition payment idea doesn't get talked about very often as a gifting strategy, but payments made to an educational institution are excluded from gift tax entirely with no dollar limit. So it could be, a way to layer on some gifts if you're looking to make gifts like that. So make sure your Windward team is looped in if it's something you want to consider, and we can kind of help maximize in an efficient way, what you're trying to do. So finally, the last piece on here is about charitable planning. And there are a lot of opportunities to be strategic if you're charitably inclined. A couple of those: donor advised funds, charitable remainder trusts, charitable lead trusts, qualified charitable distributions from IRAs. All of those can serve your estate goals, but you're still supporting causes that you care about. And it might also reduce your taxable estate at the same time. So under the one big beautiful bill, which went into effect last year, there's a new floor this year, 2026, when it comes to charitable deductions, which means your charitable giving deserves really kind of a fresh look if you haven't talked with your Windward team about it already. So all of those pieces are conversations that happen most effectively when your estate team works together with the financial plan, not in a separate silo. So the next slide is really keying in on beneficiary designations. So while, attendees, as you kind of look at this list, I wanted to ask Stephanie, what do you key into when it comes to beneficiary designations? And as a second question, where have you seen clients miss instructions or fail to complete the task, and what was the impact?
Mhm. Yeah, so whenever I meet with a client, I typically will tell them if they take nothing else away from our meeting and if I never ever see them again, just get beneficiaries on all of your stuff. It's so critical. It's an easy way to avoid probate and again, transfer your stuff efficiently to your beneficiaries. A common place that people might miss doing this or just think, I'm not going to mess with it, that I see is vehicles. So on a vehicle, you can add a TOD on the car title to the name of a person or a trust, depending on your plan. And a lot of people think they dread going to the DMV, waiting in line for anything there. So they just put it off. They may not even care to add a transfer on death designation for this $5,000 vehicle. It's just not worth it. So in that case, if something unfortunate happens to them and they pass away without the TOD, that car is now passing through the probate court to get dispersed to the beneficiaries, and you're paying an attorney like me $1,000 to probate a $5,000 car. And I mean, depending on the asset, it just sometimes it's not even worth it to mess with. So a lot of times people think it's not a very valuable asset. I don't really care. I'm not going to mess with it. But I try to steer people away from that because no matter the size or value, having a beneficiary designation will just save your beneficiaries a lot of headache down the road.
Yeah, it's a good point. Partly, we often say, um, hey, you got your estate things up to date, and your estate attorney, like Stephanie said, here's instructions. So like next time on a car, go to the DMV. And I often say to people like, don't maybe don't worry about it till the next time you go in to renew your plates or whatever, your tags. But sometimes now I can just do it online. So that makes it one way that I might forget about my TOD thing. You can go
Hmm.
into the DMV just to update it. That happened to me just the other day, last month, and the person next to me was like, "I don't have anything to do other than add a TOD," and they're like, "Yeah," and it took no time. It was amazing. So I think it's really smart. The other thing that stands out to me on here is just that point of a lot of times the place where people have the most amount of wealth is in things like their retirement accounts or IRAs, and the beneficiary designations are what determines what's going to happen with those. So it needs to be reviewed and made sure it's up to date.
Yeah, I'd say major life events. Typically, if something major happens in your life, the loss of a spouse or a divorce or a change in children makeup, I mean, those are all good excuses to check beneficiaries. I'll never forget it. We litigated a case for a poor kid his dad passed. He had gotten a divorce several years before, but the ex-spouse was still named as beneficiary on his very large IRA, and ex-spouse got to keep all of that, and the child was left without because, again, after the divorce, dad did not take the ex-spouse off and put the child on. It was a unfortunate situation. So big life events, double check how everything is titled.
Yeah. Yeah, absolutely. Which is a good segue into the next slide. We talk about, hey, when does it make sense to reconnect with your estate planning attorney? You already kind of hit obviously a really, really important one, major life events. Um, what what do you do, Stephanie, in terms of when do you reach out to your clients? What do you recommend to folks who update estate documents with you?
Sure, absolutely. So I always tell my clients reach out whenever. Please don't, there's no barrier here. We have a communication, we can update as needed. But if I don't hear, even if I do hear from you, actually, I have my clients on a fun little spreadsheet. And 4 years after the date they've signed their documents, I will send them a letter. Very simple, just checking in, making sure is everything still right? Would you like to meet to refresh? What, if anything, needs to be done? And I think 4 years is kind of a nice little midpoint. There's a potential for life change in there, and it's not over burdensome with a letter every year or two. So 4 years is kind of my sweet spot at this point.
Yeah. Which is good. There's a note on the slide there that says more than 10 years. That partly I think goes back to the fact that if it's more than 10 years old, you had stuff that was language pre 2017 estate. You really got to get it looked at. But you shouldn't wait 10 years every time. It's
Right.
just a good rule of thumb. And in general, there were the, laws that happened in 2017, but I often talk to people to say if your estate stuff hasn't been looked at since the Secure Act happened in 2020 and 2021, that's another reason likely
Mhm.
to check in, which again fits within this 4 year thing, but that makes sense too, right?
Absolutely. Yes.
Yeah.
And I if someone calls me and they're like, hey, can we review this? I need to make sure it's still good. I'll meet with people and kind of determine their goals, make sure I know what they're wanting to see in the documents. And if the documents still meet those goals, there's not necessarily a need to change anything or update documents. It's more of just a check-in to ensure goals are still being met with
Yeah,
life change, with tax law changes, with all of the other occurrences.
right. Yep. So that next slide is going to just have some ideas of questions to ask your attorney. questions worth asking your attorney. And one thing that I was curious about is are there patterns or questions that clients are bringing up more frequently to you with their estate plans?
A very common question I get is, do I need a trust or is a will sufficient for me? And I like to think of the question. I think most people need a will. That's kind of, we'll set that aside. Most people need a will. The proper question that I'd like for people to start asking is, do I need a trust or can I get by without a trust? Do I not need one? So that's a common conversation that I'll have
Yeah.
right up front with the clients.
Yeah. And it comes up quite a bit as people are realizing they need to either if they haven't done estate documents or they've had, a will-based plan in the past and that just intuitively is, gosh, do I need it or not? And
Yeah. A lot of
um
times it's keeping up with the Joneses too. I'll get
yeah,
people in, they like, my neighbor got a trust. I want a trust too. And we'll have a conversation and maybe they have two kids and they want everything to go equally to the kids. You don't necessarily need a trust in that
right,
situation, even if you have $10 million potentially.
right.
So it's very situational and
Yeah.
specific to your
And
circumstance.
it's a lot of that language just it's not used all that often. And there's just natural confusion around it. And so it's partly, I don't, most of the folks I see, it's not so much that it's like a fear of missing out on a trust and, whoa, wouldn't it be so cool if we have a trust? But it's just like, oh no, I'm supposed to do that because I heard other people say they had it. And so I think that's good clarifying language just from, literally an attorney who says a lot of times it might not be that you need it.
Yep.
Yeah.
Yeah, I like to wow clients by underselling them on things. Like, yeah, we'll get you something a little more efficient here, and you don't need to pay that much.
Yeah. And, when we had talked, previously, it was helpful to me that any of these questions here or questions that you may have are often things that people should just check in with you on. A simple question is often a phone call. It's not
Hmm.
that we got to do a whole thing every single time. Um, and it just seems like where folks may, feel like, oh, geez, if I reach out to my attorney, I'm gonna have to redo everything. That isn't always the case, is it?
Correct. Yep. And I like to try to, it's not necessarily an open door policy, but man, if my clients have questions after
Yeah.
we've executed documents or 4 years later when something comes up, they give me a call, we discuss it, talk them off the ledge, or say, nope, you don't need to update Junior's address, you're fine. And they go
Hmm.
on their merry way. It's as simple as that.
Yeah. Yeah. No, that's helpful. Um, Emily, what's next?
Well, I just want to take a minute and talk about Windward's approach to estate planning, just kind of wrap it as we're kind of wrapping up our presentation here, and why it matters. We hear from new clients pretty regularly that their estate planning has always felt like a separate conversation from their investments or their tax plan, that they meet with their financial advisor, they meet with their CPA or tax preparer, and then they separately meet with their estate planning attorney. And each of these conversations is happening in its own lane without much awareness of what the other is doing. And that's how opportunities get missed, is when there's no overlap and sometimes significant ones, like the example you mentioned, Stephanie, about the son and his dad's IRA. Um, at Windward, our three pillars: develop a plan, save taxes, and preserve capital, each have an explicit estate planning dimension. So when we develop a plan, we include your wealth transfer goals alongside your retirement income goals. When we're focusing on saving taxes, we're looking at basis planning, gifting strategy, like Drew talked about, and the income tax implications of how your estate is structured. When we focus on preserving capital, we're thinking about how your wealth passes across generations, not just in your lifetime, even though your lifetime comes first. Uh, we work alongside your estate planning attorney. We're not a substitute for one, and we never will be. But our role is to make sure that when you sit down with your attorney, you walk in with a complete picture of how estate planning hangs together with your financial and tax situation. So, with that, I want to thank everyone for their time today and joining our presentation. And I especially want to thank Stephanie for joining Drew and I today. Um, I know we covered quite a bit of territory, so um, if you have any questions, you can go ahead and drop them into the chat box now. And if not, you can always email them to info@windwardfp.com if you think of a question later.
Yeah, so there's a specific question, that is a Windward client that has, and we'll make sure to get back to you with that answer. So that we'll follow up after the meeting on that. A question that, I hear a lot is, Stephanie, what if I put documents together here in Missouri but then I move? Um, do I need to get them updated?
Yeah, that's a very common question, and especially as you enter retirement, maybe you retire to Texas or Arizona or somewhere warmer. That sounds nice to me, but typically, if your estate planning documents are entered into properly in the state where you lived when you did them, they're good. They don't expire or become invalid just because you move states. Now, that being said, if you plan to go to a certain state and stay there for the remainder of your life, or at least the foreseeable future, you might want to consider updating your documents to conform them with that state's requirements or any nuances they have.
Yeah,
Especially there are certain states, they are community property states, which we're not here, but there's just a whole different implication of stuff that you own in those states versus where we live in
yeah.
Missouri here. So it kind of depends on the situation. Typically, you can get by keeping your current documents, but depending on the situation, you might want to update them.
Yeah. If if another attorney created my documents and I came to you and said, I know I need to make some updates here, is that generally going to mean starting from scratch?
Not necessarily. So I'm a fan of efficiency. We can typically, while we're sitting in a meeting, kind of thumb through the documents a client might have and determine pretty quick, does this meet your goal? Does it not? Oftentimes, if I get documents that were drafted by another attorney, especially on their forms, I'm not familiar with them. It's typically more efficient to kind of start fresh.
Mhm.
Just with, again, a document that I work with every day, I can get that to you much quicker than going line by line through your current trust to kind of piece things together or other documents. But
Yeah,
typically, a trust is where we would see that. So, for efficiency purposes, which means cost savings, ultimately, it's sometimes best to just start clean.
yeah. And that is helpful to understand, and you really get to the heart of it, is that I think some people become afraid, oh geez, if I need to switch, to a different attorney, that's just going to be so much more of a cost because it'll mean everything is new. Well, it might be more efficient than trying to
Right.
piece together
Right.
what's already there.
Yes, and I'll say even I have clients come in and their goals have completely changed from when we did their first
Yeah,
documents. And even them, I know their I my lights went off. Sorry. I know their document. But if their goals have changed enough, maybe they're adding in a person who wasn't in the original document or they're taking someone out. Starting fresh, even in that case, with a new restatement is a good idea.
yeah, yeah. No, that those are good high level things. Um, we've had some clients as, possibly as they age or if they don't have kids, they've been in a question of kind of saying, what if I don't know who to name, especially for my power of attorney documents? Um, what have you seen on that?
Yes, so that is fairly common, especially with the blended families and the fighting.
Right.
It's kind of unfortunately becoming more common, but there are firms and companies now, one in Overland Park that I have worked closely with in the past, but they perform those fiduciary roles, the power of attorney roles for clients. So if the client doesn't really have a close family member or friend to be their power of attorney person, this company can step in and kind of run the show for them. So there are other options out there.
Yeah. Yeah, no, that's really great. And as we were talking about that separately, it kind of was like, ooh, we, as a Windward company, like we want to have some of those resources on hand to be able to kind of point people in that direction. So it's helpful. Um, Good question um, in the chat. So in regards to step up of basis, and Stephanie, you can answer.
I love this question.
Yeah. So if your residence was bought a long time ago for a lesser amount, say 100,000, and today it's worth 800,000, held until passing, do the beneficiaries pay tax on the 700,000 gain?
Yeah, so good news. The answer is no, they do not. Especially, well, assuming your estate plan was done correctly and your beneficiaries inherit that property from you at the time of your passing, they will get what Drew mentioned earlier. It's called the stepped up tax basis. So your beneficiaries will inherit that property at its $800,000 value, the time of your passing. If they turn around and sell it immediately, they will pay taxes on $0 of gain because what they sell it for, 800 minus their new stepped up tax basis, 800 is zero. So it's a fantastic way to avoid a ton of capital gains taxes. A common mistake I see people make in this realm is they put Junior's name on the deed right now. So rather than Junior inheriting the property and getting that stepped up tax basis, Junior gets a transferred tax basis, which
Oh,
means that when you pass, Junior's tax basis is whatever you paid for the property, the $100,000. If he turns around and sells it for 800, he does pay capital gains tax on $700,000 worth of gain. So if your capital
Yeah,
gains rate's 15%, I mean, you're looking at 140. No, that's too much.
talking a
$100,000 of
lot.
capital gains, a lot of money.
A
So,
lot of money, and that
yeah,
falls into the realm that we talk a lot about of like part of what we feel like we help people do is avoid major mistakes. And that's a really, really good point, Stephanie. And it, you know, naming kids on accounts needs to be considered thoughtfully. So obviously houses, but bank accounts, there's considerations there, but investment accounts especially, where if they're named on the account is different than, having access to the account, or
right.
if you want them to help with, power of attorney considerations. So yeah, that's a really, really good point.
Yeah. And in my world as well, if you add your child to your house right now, you not only he's going to pay a lot more in taxes, but you are subject to his creditors. So if he gets
Mhm.
into a car crash, gets a divorce, whatever, his creditors can attach to your house because your son owns it. Same as a bank account.
Right.
So I'm highly opposed to putting kids on assets during your lifetime. We have other ways to accommodate being able to help with bills or that. But yeah, inheriting is the best way all around for liability and taxes.
Yeah.
Yeah, that's a really good question.
I
well,
think I
if
think we
if
did it.
yeah, if we don't have any other questions, I think we'll put a fork in it. And thank you so much, Stephanie. And
Thanks for having
uh,
me.
yeah, this was great. Watch for a recording of this webinar to be available on our website. Thank you.
Thanks, everybody.